All right, so I guess it's pretty much the time, so let's slowly start. I guess more people can join us in the meantime, and whoever misses the first part can always look at that on our YouTube channel. So yeah, welcome everyone who managed to join us on the Zoom for our event. Whoever is watching us on YouTube, welcome as well. Feel free to ask questions. So this is a IEEE grant student chapter event, and today we'll have a talk about the intellectual property, startup, commercialization, how to get maybe money out of your idea. And here we have for that, we have Milda Saenz and Chris Wohlgamuth from the Office of Technology and Commercialization of the University of Texas at Austin. So, well, in the meantime, enjoy the talk, prepare your questions, maybe fill out the invention forms if you must in the meantime, and prepare your questions. There'll be plenty of time for the Q&A afterwards. If you have a very urgent question, you can always just raise the hand or ask it in the chat. And during the presentation, the speakers will be happy to answer your questions. So Chris and Milda, the floor is yours, and welcome.
Great. Thanks, Dimitri. Thank you, everybody, for being a part of this today. Milda and I are very excited to provide this information to you all and to just have this conversation. And as Dimitri said, if there's questions, feel free to ask. You're not going to offend mine or Milda's feelings if you do. So before we get into the nuts and bolts of intellectual property, the startups and commercializations, wanted to take a quick minute to just kind of introduce ourselves to you all so that you have some confidence in what we're saying and who we are. So quickly about my background, I have all my degrees in physics. I spent just over 4 years at Ohio State's tech transfer office, and I've been here at UT for just a little over 1.5 years now. And I have passed the patent bar, and so I am a registered patent agent with the USPTO, which just is a fancy way of saying I took a test and I completed questions. So Milda, if you have any, you'd like to introduce yourself.
Yeah, thanks, Chris. Hi, everybody. Thank you for this opportunity to be here. My background is in law, and I'm coming more from industry/legal background and working in tech transfer in Ireland before I came here to the United States. I've been with UT almost for 5 years now, and I work with a significant focus on business development approaches, probably. That would be correct to say. So let's start our presentation. Let me just introduce you to UT's Tech Transfer Office and how we operate and what we usually do. This office is established through UT's Regents rules. I don't know if you're familiar with UT's Regents rules, but this is a big, basically our law, UT's bylaws, how the university operates on different aspects of the research student relationship, and also intellectual property has a special rule, 9010-1, and it establishes our office presence in UT and also how the intellectual property is handled. So basically, to sum it up, all the work that is done in the university within somebody's scope of work, it is owned by the university. So all the research that is developed in the university is considered to be university's intellectual property. Intellectual property is also as a property, and the university seeks to commercialize this through the licenses, and the money that comes in through those licenses is split between the university and the inventors at the 50-50 ratio most of the time. So a little bit about our process. The research that you work on, and if it comes up into something tangible, some product that is more than just an idea and more than something that you just discussed in paper, you have some end result and something that can be developed into a product within, say, 5 years time frame, it would be considered a pretty tangible research product, and university would require you to disclose that as an in the form of the invention disclosure. We would then evaluate that invention disclosure, and we will seek an appropriate legal protection. Copyright or software has an immediate legal protection, and Chris will be talking about it later on, but technology that needs to be patented has to go through some vigorous patenting process. Again, we'll be talking about that. So first of all, we get your disclosure, then we evaluate it, and we start filing for a patent application. We market this technology to get the feedback from the industry to see whether we want to go further with the patent prosecution or there's just no interest from the industry. And then we'll be taking certain approaches how we're going to deal with that patent application. If there is interest from the industry and somebody finds a great fit into their existing technology portfolio, or they want to spin out a new product, they will license this technology from the University of Texas. Or if some of you are interested in having your own startup, the university will work with you. We have a lot of resources that will help you start a company, and then that startup company will license from the University of Texas. So our end game is basically licensing this technology once it is protected. And when we start getting income, we split the income between the university and the researchers. Just wanted to give a few words about some notable UT inventions that we have successfully licensed. Licensing takes a long time, and turning research into a product takes even longer. In physical science, that is extremely long. Most of the time, it's about 5 to 7 years to see a product on the shelf. Some of the technologies that we successfully spun out, and they are in the as a products right now, is vibration for the cars, software analysis, basically blocks the vibration, is for the high-end cars. And Dr. Adam Heller's glucose monitoring system, which was spun out in a startup company, and then it was acquired by a big pharma company. Tamper-proof oxycodone, the oxycodone that would just melt in your stomach and could not be broken up for use other than it is intended. And of course, Professor Goodenough is the inventor of the lithium-ion battery before he joined the university, but he has committed to advancing this field. And we have had quite significantly a lot of disclosures from him, and some of them were spun out to be products in collaboration with Hydro-Quebec. Okay, so next slide maybe, Chris. So just a few words about our process. So you as inventors engage with the University of Texas through the disclosure. Of course, you're very welcome to reach out to us, ask questions, and have calls if you have more questions and want to follow up. But if you have an idea and you want to advance towards commercialization, we encourage you to submit an invention disclosure form. Basically, the invention disclosure form just asks, who are the inventors? So explain how are they affiliated with the university. Maybe they are from different universities. What is your idea and what is the end product of this? Your funding sources, that is very important because we have to share this disclosure information with some funding institutions like NSF. And then from there, we'll take it and start performing due diligence, patentability, prior art. We'll have a lot of calls with you to establish the best patenting strategy and best patenting position. And then we'll start marketing process. And if successful, we'll start negotiating a license agreement. Now, Chris, I believe you have some more to tell us about IP.
Yeah, thanks, Milda. So Milda's mentioned two ways of protecting intellectual property, and intellectual property is really a larger umbrella than just patents. There on the left-hand side of this table, what we're all likely familiar with is what's called a utility patent. And this is for a novel drug compound, a new clutch system for a car, a battery chemistry for a lithium-ion system. You can kind of really get creative with utility patents and what they all are. And the protection of a utility patent lasts for 20 years from the date from which it is filed. So it's not an indefinite time period, and that's all that we can protect for that utility patent. Now there's a few other ones, a design patent and a plant patent. These are less used by our office, but it's not saying we can't do them. A plant patent is exactly what it sounds like. It's a patent on a particular plant, with one small difference is that the plant species has to be asexually reproduced. It, as well as the utility, are 20 years from the date of filing. A design patent is exactly that. It is a ornamental design of something. So if we consider, your iPhone or your Android phone that has a curved bevel edge, well, that curved bevel edge would be a design patent. It just talks about the curved design of the edge. It doesn't actually protect what the material is of that curved bevel edge. It doesn't really speak to anything of what the material is made out of. It just says it's curved. Very kind of straightforward. The copyright, which we've mentioned before, are books and pieces of artwork and music and things like that. Pictures in some cases, such as the Mickey Mouse example here. A copyright is obtained as soon as the author is able to put the intellectual property into a tangible form, a tangible medium. So that could be pen to paper, it could be keystroke to text in a computer program, kind of whenever, however you can tangibly put that into a medium, that's when you have your copyright. And the copyright is, as you can see, extremely long. It's the life of the author plus 70 years. That's why Mickey Mouse is still under copyright protection to this day. The last two remaining types of protected pathways are trade secrets and trademarks. A trade secret, great examples, the Coca-Cola formula. Nobody really knows, except for the few people that actually mix the products, what is in the formula, what are its ratios, what is the exact chemical makeup of everything. And the trade secret remains protected as long as it stays protected. So as soon as that disgruntled Coca-Cola employee who worked on the formula leaves, he could share it, would probably get sued for that, but that's something that has to be taken into account when you talk about and discuss trade secret protection. Trademark is the other type of protection that you can go after for intellectual property, and it is the words, symbols, and logos. Coca-Cola's very distinctive kind of script lettering is a trademarked design. And as long as the business uses it, then it is protected underneath trademark. Not getting any. Okay, sorry, I don't know why it was so laggy there. So right now I'm going to focus a little bit more on what I think would be beneficial for the audience here when I speak about requirements of patentability, specifically looking at utility patents. So the widgets and the architecture of circuits and things like that. So there's 4 requirements that the US law has implemented and the Patent Office follows. And I'll go through a stepwise discussion of these. The first one is a 101 statute, and this defines what may and may not be patentable. Some things just are not patentable subject matter. The mathematical formulas, the natural phenomenon such as gravity, those things are not patentable. You can't preclude other people from using the law of gravity in everyday activity. So that is something to keep in mind when thinking about, can I patent this? It has to first clear that threshold of statutory subject matter. The other thing for 101 rejections is software. Software is generally held not to be patentable unless you are able to connect that piece of software with some type of physical device. One idea would be if you can use that software to improve the writing bit rate of a particular piece of computer hardware would be an example. Or you're able to overclock your computer using a particular piece of software. You're directly connecting the software to a piece of hardware. The second requirement for patentability is novelty. And the basic question here is, does it already exist? I can't go out and try and patent a Bic pen or a Yeti coffee mug here, directly reproducing it. I cannot get a patent on that because it already exists. The third form, or the third hurdle to overcome, is a non-obvious question. And this becomes a little bit gray. The thought here is, could I take a combination of known pieces of prior art or publications and combine them to say, well, if I take A, B, and C, I get your product of Z. Now, the reason why I say it's gray here is because from a legal perspective, there are no maximum amount of prior art references that can be used to make the combination. So if it requires 12 different things, then the examiner could say it's obvious to combine and get to where you are at with your product. This is where we employ our outside legal counsel to make strong arguments as to why combining 12 things is not obvious and it should be allowed subject matter. The final thing is a 112 or an enablement requirement. And what this is trying to do is provide the patent office and other people, once the patent becomes expired, to use and practice the invention that you have come up with, and not have to guess as to how you were able to come up with what you're claiming is a novel invention. So essentially, have you written it down sufficiently enough so that your colleague or colleague at another university could pick it up and reproduce your results? So that's something also to keep in mind when we're talking about patentability. So these are the four thresholds for acquiring and achieving a patentable subject matter invention. So Milda's going to talk a little bit more now about the timeline and these things.
Yeah, thanks, Chris. So basically, the timeline of the patent is arguing with the patent examiner that we're fulfilling all those four requirements in our patent application. Let's start from the beginning. US law allows provisional patent filing. Provisional patent filing does not exist anywhere else in the world except for the United States. Also, United States gives this grace period where after 1 year after publicly disclosing the technology, you still have the ability to file the patent application in the United States only. So if you have a paper pending and it's about to be published, it's crucial that you get in touch with the OTC and you start evaluating the technology to see whether it's ready to be filed as a patent application, and if we believe that we can meet all those four requirements. So once we get your invention disclosure and we see that it's a chance to file a patent application, we would file a provisional patent application, and it is good for 12 months. And after 12-month period, we have to decide whether we want to file it in the United States only, or if we want to enter into this patent treaty agreement. It's in the International Patent Treaty Agreement, PCT, for 18 months, and to hold our place in basically worldwide in all of the patent offices. So combined, we have 30 months to enter national phases from the day of filing. This 30-month time period is crucial to get industry's feedback, to get you up to speed to the highest technology readiness level when it is commercially viable. And if we get no positive feedback and the research is lagging, there is no funding, there's a lot of things might happen in the meantime. We might consider our position and not continue with the patent filing in the national phase. Or if we find a licensee, and licensee is an international company, or if you are a startup company that wants to do an international expansion and see the value of having international filings, that patent has an opportunity to enter all those international patent offices. Each office conducts their own patent examination. So let's just talk now about the United States. So after those 30 months window, we enter into US patent stage. And the examiner is assigned to review this patent application, and they will measure our patent against existing prior art to see if we meet all of those requirements. Basically, what is happening for the next 2 or 3 years will be fighting with the examiner, trying to rebuttal their position that our patent claims are somehow not matching those requirements. And we'll have to come up with the position that we're taking and prove that actually what the examiner is claiming to be is wrong. This is a very challenging and a very, very expensive process. And maybe we can get to another slide where we talk about the budgets. Okay. So the US provisional, we've tried to file as finalized patent application at that stage as possible because we want to make sure that when you publish, we have all the claims covered in the patent, and we do not shoot ourselves in the foot by disclosing something that is not covered in the patent application. So $6,000 to $10,000. To enter the PCT, the filing fee itself is about $3,000, and then the additional filing has to be made. So we're looking into probably $5,000 to $6,000 for that one only. So 6 plus 6, already $12,000. And we just, in the first 12 months. So the next 18 months is basically a quiet moment where we gather as much data as possible and market this technology as much as possible. And at the national phase, since we already have a pretty well done patent application, we would spend about $3,000 to come to nationalize in the United States. University of Texas, due to the budget restrictions, we do not have ability to nationalize outside of the United States. So if you do not find a licensee within the 30-month window who takes this patent internationally, this patent will remain in the United States only. So basically, each office action, that's the rejection that the examiner issues. A response to an office action or the arguing part costs about $4,000. And it's becoming more and more common to have more than 2 of those. And then there might be a final office action issued, which completely rejects everything. And then you have to issue an appeal or choose from other more pricey opportunities. So all in all, we're looking over $20,000 to have a patent issued. We do not know how broad our claims will be allowed, so there's a big risk that we take. And the claims is what matters the most, because when we license the patent, those claims is a monopoly basically over that invention that excludes others from copying or making what is claimed in the patent. And that's that monopoly, that was the rights for excluding others for copying and making or importing in the United States or wherever the patent is issued products with those claims is something that our licensees are looking forward to. All right, I guess that was it. That was a quick overview of the patenting process. And now we're ready for your questions.
All right, so I think there is actually one question that just came recently to the chat. So in cases where you file internationally, how do you decide which countries you elect when you file a PCT application? That's from Brian.
PCT itself is valuable worldwide. So PCT application is an international application by itself, but it's not a nationalization. It's just a placeholder basically to enter into international offices.
Yeah.
As I mentioned, university in its cases does not enter into outside jurisdictions due to budgetary restrictions, because each of them require additional translation and additional filing. So it's about $10,000 just to nationalize outside of the United States before we even start the patent prosecution. So it's just very, very expensive. But if we were to do that, we would see who is the major manufacturer in that field. So let's just say battery technologies are mostly China, Korea, Japan, Europe as well. You also see which markets are the biggest markets that would use that product and who would benefit if the product was to be imported into their countries. So there's a lot of things to be considered, but we would like our licensees to make those decisions because they're the ones who benefit from the strategy to having a certain patent in a certain country.
Good. So if anyone has a question, please unmute yourself and you can ask a question. I can just type it into the chat. In the meantime, I could perhaps, we've been collecting a little bit some of the other questions prior to that. So I have some questions. So are there some sort of state rules for patents, let's say within USA, or it is all, regardless the state, it is all equal?
It's just the US. So even though we are in Texas, but the university is a state entity of Texas, it would still be applicable to California, New York, Florida, Alaska, 50 continuous states. So there's no need to file individually in each state. Once you have a US patent, it's good for all US states.
Okay, got it.
I'll ask one if y'all can hear me okay. I'm just curious, how many applications does the university file in a typical year?
Depends how many disclosures we get. And we file probably on about 60-70% on the disclosures. So my guess would probably be close to 100.
Yeah, I was going to go 80 to 100.
Yeah.
If we take a low end account of 50% and then an upper of the 60-70% filing rate, then 80 to 100, maybe 110. And that is looking at not just new disclosures, but also there might be some conversions that happen in that year that we file on as well. So if we go from a provisional to a US or a provisional to a PCT or PCT to a nationalization into the US, those are counted in that number as well.
Thanks.
Mm-hmm.
Another question, would it be, I mean, I believe early it was possible, you know, people were patenting, you know, pretty much everything. They would just thought of an idea and then they would patent it, regardless even if it has been even done yet or not. Is it even feasible, possible these days? So let's say I think of this idea, I think it might be possible, but I haven't realized that practically, so there is no practical proof that it is possible. Would it still be possible to patent, I don't know, flying car?
Right.
We have the flying car patent applications.
Damn it.
I mean, you could try without sufficient enablement, though. I think the examiner would come down with a 112 rejection saying, you know, your perpetual motion machine that you're claiming you have, how does it work? You know, you've got to be able to convey the invention in sufficient manner that someone skilled in the arts is the legal verbiage. Someone skilled in the art can look at it and say, I can reproduce this, and then I could have a perpetual motion machine.
I would also add, you might file for one thing, but during the prosecution, your claims get narrowed so much that you end up having one or two claims that are not exactly what you intend to have. And you end up with like $100,000 bill because you just have so many rejections and you're coming up with the new strategy. So it's basically that trade-off.
Let's see. Yeah. And I guess one last question from the pre-questions that we had. So what, for example, so what is the deal with, let's say, insulin, or like those kind of patents that have been expired for even more than 70 years, but they still kind of, you know, cost, I mean, the production is cheap cents, but they sell them for hundreds of dollars. How is it justified, and how would, I mean, why are there no other people who can say, okay, I'm going to produce it and I'm going to sell it for $2 instead of 100?
Is this the drug-related question, Dimitri? I didn't catch that first part.
Yeah, like an example of insulin, for example.
So the drug development world and the pharmaceutical world is a very unique world. While the original application on insulin probably expired, like you said, 70 years or so ago, I'm not sure the exact date. One of the things that we didn't mention here that we can get more into the weeds on regarding patentability and patents is you can file patents on top of patents and kind of extend the life of these patents. However, to do so, you have to have you can't introduce new matter, but you're filing on slight changes to the original composition, in this case of insulin. So if insulin originally only required a handful of products, and then it was discovered that, well, there's this one molecule that if you add a particular ligand or functional group, that doesn't really do anything, it just changes the chemical nature. I can file on that and get a new patent on top of that. And so it's a tricky game that the patent attorneys for pharmaceuticals play when they're doing these continuations on top of old patents by adding non-deleterious material to the drug, but is a new composition at that point, if that makes sense.
Yeah, interesting.
And I would like to add that pharma companies or any other company, they are playing basically pricing wars. And if they can ask in the United States $100 for an insulin shot, whereas in Europe, the government mandates that the insulin shot shall not cost more than $20, it all comes down to a lot of other things. So it's things that Chris was talking about, but also a lot of things that are just because of the companies can't take advantage of that.
Correct. Right. Thank you. So if there are any more questions from the audience, would be happy to answer.
How does the university handle infringement? If you detect someone infringing, is that something that the university would handle on the litigation side? Does the licensee pick that up as part of their agreement? How does that work?
Right. So it's going to depend upon the particular agreement. We've done it both ways where the university may be the first one to enforce the IP against the infringer, but some companies want to have that ability themselves to enforce first. And how the particular company, our licensee, goes about doing that, that's likely going to be their call, whether or not they get litigation financing or if they want to foot the bill themselves. And for us, I haven't been here to know how, or I haven't been here long enough to know how we would enforce our IP. We try to approach the company and ask them if they'd like to take a license so we don't have to go down that pathway of litigation. But then we also have to consider what is the ROI on litigation versus not litigating. These are millions of dollars in legal fees that we might be looking at this point. Milda, do you have any recollection from you being here long while litigation?
So we had some battery patent disputes, and thankfully we had a licensee who was enforcing those patent claims, and university shared that revenue. But that was the licensee who did. University doesn't really have a lot of resources to do litigation and enforcement. It just costs too much money and requires way too many resources.
Thanks.
Sure.
All right. So I guess if there are no more questions, thank you both very much for this talk, and I hope it's going to be useful for the students. And anyone who's listened, I guess, are very much welcome to follow up with Chris and Milda if you have some ideas, or have some more questions. I believe they'll be happy to answer.
Yes, thank you very much for having us. Thank you for your attention. I would encourage you to check OTC's website, otc.utexas.edu. There's a lot of other resources that you can look for, and if you're ready to submit an invention disclosure, forms are there. I believe you have our email addresses, so you're welcome to drop us an email anytime, and we can have one-on-one call, and we can answer more of your questions.
Thank you very much.
Okay.
All right.
Well, thank you, everybody.
Thanks.
Yeah.